The following program is for informational and educational purposes only and is not to be considered legal advice. Fraudsters Radio was created to expose the many scams and frauds that have so infected society today. Scammers, fraudsters, and rip-off artists abound, whether it's scamming homeowners with bogus foreclosure relief services, dating fraud, incompetent lawyers, or consumer rip-offs. It's high time the public has a voice. If you work in a profession that deals with fraud, or if you believe you were or are a victim of fraud, you now have a radio listening public that wants to hear from you. Please feel free to message us through our Fraudsters Radio Facebook page, and we may have you on the show as a guest. If you'd like to call in for today's show, the number is 646-668-8512.
And welcome to another edition of Fraudsters Radio. Glad to have you with us today. I am Laurie Z, nationally syndicated radio host, along with my co-host, Storm Bradford, the owner of Mortgage Fraud Examiners. And we have a special guest, attorney Christie Arkovich. Welcome to the show, Christie.
Thank you. It's a pleasure.
Now, Storm and I talked a little bit before about this topic, so and I've spoken to you previously on the phone. We want to talk about the Telephone Consumer Protection Act, the TCPA, because I know you know a lot about that topic, and I know people struggle. Like, I get really annoyed when I get dozens of phone calls. I actually disconnected my home phone because every single phone call is a solicitor, and I'm on the donotcall.gov list. And so I find it frustrating that no matter what I say or what I try to do, and these people spoof their phone numbers half the time, it's gotten to the point where I don't even pick up my phone unless I know who's calling. So we maybe start out with an explanation of what the TCPA actually is?
Certainly. The state of the law right now with robocalls, it's kind of like the days before email spam filters. You remember those days where you get, 100 emails from stupid things? Well, now we have those spam filters that fix that. But with robocalls, it's a little harder because they do, like you mentioned, they spoof the call, so they keep changing the phone number they're calling from. So there's a lot of different blocking mechanisms and applications and software you can use, but they just choose another phone number. And nowadays with internet businesses, they don't need expensive hardware. Anyone can start a mini call center with software that auto dials and spoofs caller IDs, and sometimes they appear as local calls when they're really not. And so there's some internal FCC changes in place that they're trying to create some technological changes where they're going to certify the call is actually originating from a caller that's legitimately using that number. And so that might make some changes in the future. Those regs aren't finalized yet, but basically they're intended to use rules that let phone calls be blocked from area codes that don't exist or numbers that haven't been assigned to anyone or things like that. So it may get better, but that could be a couple of years down the road. So what the TCPA does is it's a mechanism for private people to fight back. Basically what it stands for, the Telephone Consumer Protection Act, and it applies for calls to your cellular phone. And basically it has really good teeth. We like to use it because for each call that's made, there's potential statutory damages of $500 to $1,500 per call, and that's a lot more than the FDCPA, the Fair Debt Collection Practices Act. Here in Florida, we have a Florida counterpart like that, Florida Consumer Collection Practices Act. For those acts, it's only $1,000 for each act, regardless of how many calls. So you could have 100 calls and still be limited to $1,000. So we've really, over the years, we've really liked the TCPA. One of the things that I've done is we have a portion of our practice dedicated towards student loan work, reducing payments, reducing amounts due for federal and private loans. And we have had some really tremendous successes where we've either completely eliminated a private student loan or we've gotten it, say, it used to be $50,000, now it's maybe $5,000 without interest going forward, simply by using these consumer violation statutes. They have a lot of teeth, and we typically will use all of them, because one of them might provide for attorney's fees like the FDCPA. The TCPA might provide for damages. When you combine them, you have both. So we've found it really works.
Gotcha. Now, are there any punitive damages ever issued for TCPA?
Yes, there can be punitive damages as well, and also under the FDCPA. And then sometimes you can have that, particularly with large volumes of calls. If you have a very large agency and if you have actual damages too, sometimes that plays a role where someone might be hospitalized because of the frequency with the calls. They've become so stressful. Maybe they've lost a job, so you have employment damages. The damages can be quite extensive.
Christie, before we go any further, I know I'm going to butcher your last name. That's why I'd like you to spell out your name, give us some contact info, because if any of our listeners, this is something that they're, trust me, would love to give you a call, because I'm sure there's tons of them out there that would like to take your services. Could you spell your last name for us and give us your contact information so our listeners might be able to give you a shout if they need you?
Absolutely. My name is Christie. It's Christie, and it's Arkovich, ARKO, V as in Victor, ICH. And so my website is Christie@ChristieArkovich.com, and we have a phone number, 813-258-2808. And we have a lot of information on our website. We have a free ebook, How to Take Your Life Back from Your Student Loans. That's particularly popular. There's not a lot of folks out there to help with student loans, so that's why we've really tried to develop these laws in that area. But we handle other cases as well, credit card companies that are calling and a variety of debt. We're located in Tampa, Florida, and we pretty much service most all of Florida. Occasionally we'll help people out of state when it's not a state-local issue, but most of our business is here in Florida.
Okay, great.
I know there are some exceptions to the I'm not sure if there are exceptions to the robocalls, but I know for solicitations, doesn't it exclude things like political calls and charities? I think it excludes, correct?
Yeah, the Do Not Call registry that a lot of people are familiar with, it prevents sales calls, and then you've got political calls, charitable calls, things like that. It's informational only calls, telephone survey calls. What we deal with a lot in our case is debt collection calls. And one of the things you mentioned a few minutes ago is some upcoming changes. And I did want to talk with you about that. There was a case a couple months ago, a D.C. case that came out. And while it's not directly relevant to Florida and many of the other states, a lot of us were all awaiting it because everybody had agreed to hear some major issues in that particular case. And one good thing that came out of it is it's clear that people can revoke consent. And that's important because sometimes, if you've signed a contract or clicked on a website or something where you've authorized them to call your cell phone, you can change your mind and say, no, I don't want any more cell phone calls. That was actually in question about whether you could actually revoke consent once you agreed. So you can. Here in Florida, it can be done verbally. But there's some negative things that came out of that case on how they view what an auto dialer is. And so it may be harder in the future to show that a caller is using an auto dialer. We also have them now rewriting some rules because the chairman of the FCC was opposed to the FCC enlarging the law back in 2015 when they sort of broadened what an auto dialer call was. And he wants to take that back a notch. I don't know if he's anti-consumer, but he's certainly not pro-consumer. And so we may have some limitations on the law going forward. They are rewriting it, and that might come out in the next few months. The commission itself is made of 2-1 Republican versus Democrat, so I suppose that they probably will vote in favor of Commissioner Ajit Pai. And then we have, just in the news a couple weeks ago, we have our Supreme Court Justice Kennedy resigning, and that makes any appeal on the TCPA issues more likely to be pro-business. So there's going to be some changes on the TCPA going forward that is going to make it harder, unfortunately, for a consumer to bring a claim.
I got another question for you, Christie. You said when you were starting off that this applies to cellular phones. Doesn't it also apply if somebody called you on your home phone?
No, not the TCPA. The Fair Debt Collection Practices Act, it does apply to those kinds of phone calls. All you need to do is send a written cease and desist, basically a letter that says don't call me, and send it certified mail so you have proof of sending. The TCPA is only for cellular phone calls.
Okay. So that's good to clarify that for our listeners.
Yeah, and I'm going to throw you both off on this one. A lot of the home phones now are actually cellular phones that use a box to connect up to your regular phone. So I'm questioning, does that now make it a cellular home phone? as opposed to a landline, because a lot of the a lot of the carriers have actually stopped using landlines.
Yeah, the case law has pretty much come down in the favor of if it is the consumer that's making the change. Like, let's say it's a landline call, and then they've instructed it through software or whatnot to go to voicemail to their cell phone. Since it started out to be a landline call, it's going to be deemed to be a landline call because the consumer made a decision to make it cellular. So they're not going to blame the business for making a call when they didn't know it actually ended up on a cell phone. Does that answer your question on that?
Yeah, and I was going to say I lost my train of thought. Storm, question.
Yeah, Christie, I had another question as well. Under the Fair Debt Collection Practices Act, it's 16 U.S.C. 1692 KA3 that an action brought in bad faith by the debtor may subject the debtor to the other party's attorney's fees. Is there anything, and this is why, for our listeners, again, they best serve themselves coming to someone that's an authority on the subject than trying to do it themselves. Is there any other such thing in this act where something brought in bad faith would subject them to the collection of attorney's fees by the other side?
Not that I'm aware of with the FDCPA. There is a lot of states, including Florida, has an Unfair and Deceptive Trade Practices Act. And I typically choose not to bring violations under that act because it does subject my clients to potential attorney's fees if we turn out to be wrong and we later lose. The FDCPA does not have that, though, so we've never yet had a client ever charged with attorney.
The FDCPA does have it. I'm saying, does the TCPA have it?
Oh, I think I misunderstood your question. Yeah, basically the FDCPA has a clause that allows for a borrower or consumer to get their attorney's fees, and it's great. It makes us kind of like private attorney generals.
No. If the debtor brings a bad faith action, they're subject to paying the creditor's attorney's fees. Is there something like that in this act that we're speaking about now?
No, the TCPA does not have that. It really doesn't address attorney's fees either way. Like your own attorney wouldn't get paid attorney's fees separate like they would under the FDCPA.
Okay.
So no, it doesn't have that.
Okay. And I got a question for you. How many times, like if somebody is, let's just say, I'm sure with student loans, they're calling from legitimate phone numbers, so you know who's calling. But let's say, for example, I'm getting multiple calls from the same phone number. How many calls does it take before, you or another attorney might take that case? Like, you don't want just one call. I would assume that you want multiple calls. And I would think that, like, if I as a credit consultant, if I have clients that are getting those types of calls, I actually tell them to log those calls with all the information, date, time, what was said.
Yeah, we ask our clients to verbally revoke consent to call their cell phone, make sure that the caller knows it's a cell phone that they're calling, and make sure they know that they're not to call it ever again. And we ask them to do that multiple times, and we ask them to track the date and time that they do that. For the number of phone calls, we're looking for really 100 plus. We often used to file cases with a lot less phone calls, maybe 20 to 50, but they take a good amount of time. And if we end up having to rely on the FDCPA, for instance, for harassing phone calls, if they aren't using an auto dialer when the facts come out, we still want a good case under the FDCPA. And there we're looking for probably 100 or more calls. It's great when the calls will come in on the very same day that someone is asked not to call. I mean, one of our last cases from last week, there were 5 or 6 days that our client ended up getting 5 or 6 robocalls on her cell phone after she had said, don't call my cell phone on that very same day earlier in the morning. And so I believe that's harassment. And even though the FDCPA requires someone to give a written cease and desist letter, it doesn't mean that it can't still be found to be harassment, even if it is only orally done. So a creditor or marketer or whoever it is runs a risk by not abiding by someone's verbal request not to call. But we're looking for 100 plus calls if possible.
Okay, got it. And before we go on, we're gonna take a quick commercial break, and we'll be back in just a moment.
Have you received a notice of foreclosure on your property? Do you suspect that you're involved in an unfair or fraudulent loan agreement? Are you looking for a way to save your home? Would you like to cut through all the misinformation and find out what really works? Would you like to learn strategies that the so-called gurus aren't aware of? If you answered yes to any of those questions, a professional team at Mortgage Fraud Examiners can assist you and your attorney with all of these things and more. Contract breaches, errors, statutory regulatory violations, fraudulent appraisals, and other fraudulent conduct cause most mortgages to be legally problematic. In fact, the Federal Deposit Insurance Corporation found that nearly 2,000 financial institutions they assessed received citations for significant compliance violations. They also examined appraisals and found out that of the 259 appraisals reviewed for accuracy, only 7 fully complied with professional standards. Call us at 844-920-7200. That's 844-920-7200. Mortgage Fraud Examiners, 844-920-7200.
We're back on with 24/7 AM radio with our special guest today, Christie Arkovich. She's an attorney in Florida. Christie had a question regarding the business relationship, basically doctrine that deals with the Act. Can you explain that a little bit to us?
Well, I haven't read the Act for quite some time, but generally the TCPA, most of our client calls that we receive are from folks who they have ongoing business relationships with a company, and they've asked that company then not to call them. Unfortunately, a lot of the calls that people receive come from different spam or scam type places. And you can identify those by, they'll say something like, well, we're going to send the process server out to serve you. Will you be home for the next 15 minutes or the next hour and a half? And they really scare that person, because that person then thinks that this company knows where they live, they're outside, and they can be taken to jail or whatnot. So those kinds of calls that are more serious usually have no business connection. And, in fact, we often can't go after them because they're fly-by-night types of companies, and it's not worth us going after and spending time and money to get a piece of paper that some Nigerian company has violated the law. But I haven't read the Act to really be able to answer your question on the business relationship. We can do that on some other show if you like.
Yeah. So, the reason why I'm concerned with it is you don't want a lot of people calling you up wasting your time, because if you've done business in the last 18 months with a telemarketer or a seller, or you made an inquiry with them in the last 3 months, under that Act, it's it's basically presumed that you've established a business relationship. So that in and of itself is not a violation of the Act.
Yeah, and you can revoke that consent. So you can give them permission to call you, and the very next week you can say, well, I've looked at this. I don't want you to call me anymore. I'm going to buy from someone else, or whatever it is.
Well, let me ask you, Christie, let me ask you, I think this would be really, really important for our listeners, and again, to maybe get it clear in their minds before they actually call you and maybe waste your time. How can I, as maybe a possible victim, or any of our listeners be a possible victim, how can we document evidence of maybe a possible violation? What would you recommend us do?
Well, first of all, you want to keep track of all the phone calls and all the voice messages. So make sure that your phone doesn't have anything that automatically deletes those. We have a lot of clients who save voice messages, and then they don't realize that they're automatically deleted off their system after, say, 30 days. So it's good to transfer them to your computer. Voice messages are great. And then, of course, the records of the calls, when you do a screen print or screen capture on your phone, it will capture what comes across your screen. It'll show the date and time as well as the caller's ID or phone number. And that's perfect. That's excellent proof. We ask folks to go ahead and put that into a call log for us so we can easily track all the phone calls. But keeping that kind of evidence is excellent. Keeping letters, including envelopes that someone might receive. A lot of these debt collection letters, for instance, are actually pursuing what we call stale debt, which is debt that's beyond the statute of limitations, and they're sending collection letters on that. And those letters could be violations. So we like to have clients keep all copies of letters and so forth too. And it's important. A lot of our violations are for calls that are under the FDCPA before 8 a.m. or after 9 p.m. So the call logs will show those times. But it's also important for you to let any relatives and references and contacts if they're getting calls too, because they might be listed as a reference on a credit application, and so your parents or your neighbor or your friends might be getting calls, make sure that they're also keeping track, because those are some of the better claims that we bring, is when a debt collector basically tattles on our consumer client to their mother right after they've gotten off the phone with them about how they're not paying their debt. And those are particularly egregious claims. And I did want to correct one thing earlier. You mentioned, you asked whether or not the TCPA has punitive damages. The actual violations are per call, which is of punitive nature, but they're actually statutory damages. We generally will bring our TCPA claims with other what we call tort claims for invasion of privacy, negligence, things like that. And those do allow you to get punitive damages. So when we combine various statutes and various torts, we can get actual damages, punitive damages, statutory damages, attorney's fees per call. You just kind of add it all up, basically.
So what we should do as consumers then, to help us help you before we hire you, is basically make a written record of the calls, the date, the time, what they said, and the caller's name. So when we come to you, we can say, look, I've got all this documented evidence of these phone calls at these dates, these times, the caller's names, et cetera, and that better helps move the case forward for them, right?
Yes, that would be fantastic, because then we could act a lot quicker. As long as our clients knew to go ahead and revoke consent by asking them not to call their cell phone any further. Correct. Now, some clients in the past have said, well, I can't talk to you until after 5. So you see, that wouldn't be a revocation. So it's good to revoke all consent to call the cell phone and make it really clear. And we usually will ask our client to say, you're calling my cell phone. That way there's no dispute on whether or not they knew it was a landline or a cell phone. And then they could follow up in writing as well. In writing, I'd want them to put the cell phone number in the letter too. And it's the client's choice. A lot of times they don't know where to send the written agreement, written request for cease and desist. With a big company, you might have 10 different addresses on a website, and they're just not really sure where to send it. And one of the nice things about this ACA International case that came out a couple months ago is it made it very clear that you can revoke consent, and any revocation that's reasonably done will be sufficient. So you can't make someone, rub their tummy and pat their head at the same time they're sending a letter to 10 different addresses. But a verbal revocation is fine here in Florida under the TCPA.
Now, this also applies to unsolicited faxes too, doesn't it?
It does. I have not been doing faxes as part of my practice. I may change that in the future, so I don't know too much about faxes, but I believe it applies definitely to those.
All right, so let me ask you a question. I have an electronic phone. It's not a cell phone. It's an electronic phone, electronic fax. Somehow I am on somebody's sold my e-phone number or e-fax number, and so I occasionally get faxes, and there's no way for me to really contact the company without calling. Would that be considered a violation of TCPA in that case?
I don't know. I'd have to do some further research. But to put the number on the do not call list, right? Did you know there was also a Florida do not call registry? Okay. Did you know there's also a Florida?
Call, yes.
Well, no. Do you know that there's a Florida list too? It's separate than the national.
No. Oh no. Tell us about that. I don't know that.
Yeah, Florida has a do not call registry as well. It's free, the same. It expires every 5 years. And it's located at www.fldnc for donotcall.com. And it has, it's another mechanism for statutory damages. It's up to $10,000 it's basically presenting, and that's per call. It's basically preventing someone from making a call from a business in the same state. So you might add your list to the Florida, or add your name to the Florida list as well as the national.
Yeah, I've actually thought about sending, Storm, here, I've actually thought about, just hypothetically, I get one of these faxes and I'm on the do not call list. Couldn't I hypothetically send that company a demand letter for $500 or $1,000 and say you violated in lieu of going to court, I want you to pay me?
I believe so. But you also have violations under the Do Not Call registry, which are even more substantial. I think it's currently up to over $40,000 per call. We haven't been bringing violations of Do Not Call registry calls, but it's something that we probably will start to bring now that the TCPA is going to have some changes.
Gotcha.
Now, TCPA, which is something else that our listeners should be aware of, is that it doesn't preempt state law. You want to explain that a little bit?
Well, like I mentioned before, we pretty much try to bring all the laws that apply in the same case. So the federal law can be combined with the state law. It doesn't preempt or eliminate our state law remedies. So the TCPA doesn't have recovery of attorney's fees for the consumer's attorney to bring the action, but the FDCPA does. So we like to combine both. If we didn't combine both and we just filed a TCPA case, then the other side would want to run us around the flagpole for a while because they want to make that case unprofitable for us so our clients can't find, good representation. If we bring just an FDCPA case, then yes, we can get attorney's fees, but the damages, unless we have actual damages, are somewhat limited. It's not on a per-call basis, so it's not worth that much for our client. It still gives us great leverage, though. So if we're trying to settle a debt, having any claim at all will drastically help us in settlement because it escalates the matter to maybe a higher-powered decision maker, as well as give us a reduction of a reduction of the amounts due. So we like any kind of violation, but we combine both of those acts whenever we can.
Yeah, I think something else that would be of interest to our listeners as well is, I don't have a lot of money. I've gotten some of these phone calls. I can't hire an attorney because, I've got a couple phone calls, but I really can't hire an attorney. It's going to be too expensive. How do you get paid? I don't have the money. I want to do something, but I just can't hire an attorney because I can't afford them. What's the answer for that?
Well, it varies. Sometimes we may not be able to help that client. Many times, though, we're able to get our attorney's fees from the other side because we have these shifting attorney fee provisions in either the contract or in the statutes that allow us to sue them for our attorney's fees. So we have a lot of clients where we won't ask them to pay our attorney's fees. We do like them to have some skin in the game, though, because we want them to show up at depositions, cooperate with getting us documents and answering questions. So sometimes we'll make them pay their cost of the action or a portion of the cost just so that we make sure that client stays in touch with us, keeps their email fresh with our client. Because if we lose track of them and we've got, a few $1,000s into a case, that hurts us. So we may have our fees where we go after the other side, but sometimes we'll have our clients pay a little bit of their costs.
Yeah, but the short answer is that if I come to you because there's a violation, it's not going to cost me $20,000 to prosecute this thing, that there's going to be
Absolutely.
some sort of reasonable fee that I might have to pay, like a witness fee or something like that, but I'm not paying you some enormous amount of money where I've got one violation, the most I'm going to get is $1,500.
Yeah, no, that would never happen. The attorney's fees that we generally are charging our clients are usually when we're defending a court action where they've been sued. Most of the time when we're taking offensive action against a creditor or debt collector, we're not charging our fees to the client. It's pretty much just against the other side. So when a client ends up not retaining us, it's generally not because they can't afford an attorney. That's usually never the reason. It's usually we don't have good enough proof. They've not kept track of things. And so when you asked earlier about what someone should do, that's the biggest thing to being able to present your case to a consumer attorney is keep track of it. Because in a complaint, we have to say, on this date or approximately this date, something happened. And if we're just randomly guessing, we cannot prevail in that case. So having the facts and keeping track of them is way more important than having money in your pocket when you're approaching a consumer attorney for representation.
Right. So the smart thing for the consumer to do then is to call you and discuss it with you, and don't go under the assumption that I won't have the money to pay an attorney to get this thing taken care of. They should call you and plug it in. Right.
Absolutely. It's the same thing with student loans. There's a lot we can do that many times has very, very limited fees. And if we're going after the other side, then we're asking them to pay our fees. So, yes, absolutely.
Okay, before we go to break real quick, do you charge for a consultation if somebody wants to come in and just talk to you and tell them what happened?
For any of these TCPA, FDCPA type things, we do not have a charge for consultation. We have started to have a charge for our student loan consultations because we give a lot of information in those consults. So we offer a guarantee, and that's only for student loans. And the guarantee is if they hire us, we waive the fee. And if we can tell them what to do and how to do it in the 30 minutes, then we can avoid them even having to hire an attorney. And then the last thing is if we can find out in the first 5 or 10 minutes that they're already doing everything they can and there's nothing else that we can do, we waive the fee. And so that gives them the assurance that they are, in fact, doing everything they can, because the student loan system is very non-transparent and nobody really knows. So I think that value that we're giving in that consultation is enough to warrant a minimal fee. And so we have a small fee for our student loan cases, but we have no fee at all for all of our other cases. Someone who might be presenting with a foreclosure, bankruptcy, TCPA, FDCPA, FCRA is something that we've been adding to our practice lately. No fees, no consult fees for those.
Got it. All right, let's go to a commercial break, and we've got more to talk about. We'll be right back.
There is a very high likelihood your mortgage contains an extensive error. At Mortgage Fraud Examiners, we know just how costly a missed opportunity can be. For almost 40 years, we have consulted, retained, and referred to by attorneys, lawyers, trial practitioners throughout the nation. Put another way, we are the trusted source for litigation support. A foreclosure is basically an allegation the homeowner breached the contract by failing to make timely payments. The contract is clear. The borrower promised they would make timely payments, and if they didn't, the lender could take the property. The only way to overcome the homeowner's breach is to show the lender breached first. Identify errors that would void the contract. Identify regulatory violations. Identify appraisal fraud and other fraudulent conduct. And the only way to find these wrongs is to thoroughly examine the whole mortgage transaction. This meticulous examination of your mortgage transaction and appraisal can identify legal defects that would make your mortgage unenforceable and entitle you to compensation or even free title to your property. Call us at 844-920-7200. Mortgage Fraud Examiners, that's 844-920-7200. 844-920-7200.
We're back on 24/7 AM radio with our special guest today, Christie Arkovich, an attorney in the state of Florida, who's explaining to us the TCPA. Got a question for you, Christie. Can you explain to our listeners what the difference between a TCPA violation and an FDCPA violation is? What's the differences between the two? How do I know when I've had one versus the other?
Sure. Well, sometimes you can have both. But the TCPA is limited only to calls to someone's cellular phone, and it has a little bit longer of a statute of limitations, 4 years, and it's basically for calls that are made by an auto dialer. And a lot of folks think that has to be a robotic voice. If they get pre-recorded voicemails, things like that would automatically be an auto dialer. Not necessarily. It depends on the actual entire system that's made by the caller, and we never know what that is in advance. As well as how they use that system, whether they've modified it, if they have any human clickers that initiate the call, whether the call is initiated by a computer and things like that. The FDCPA is basically any call that is made that is harassing in nature, that's made after you've asked them not to call, preferably in writing for the FDCPA, but not necessarily. And it limits things where someone's making a call and asserting a right that doesn't exist. Maybe they're discussing the debt when they're not supposed to with a third party. Maybe it's before 8 a.m., after 9 p.m. There's a number of violations under the FDCPA. But basically, the differences are the FDCPA can be a call to your landline as well as a cellular phone. So it can be both, and it is not on a per-call basis where the TCPA is per call. And then many states, including Florida, have a counterpart that's similar to the FCCPA. We call ours the Florida Consumer Collection Practices Act, FCCPA. Mm-hmm. And it's a little different from the FDCPA. It has a slightly longer statute of limitations. It's 2 years instead of 1 year for claims going back. And then it also applies to the original creditors as well as debt collectors. One of the limitations of the FDCPA is it only applies to debt collectors, those that acquire the debt basically after default. The TCPA can apply to anybody, and the FCCPA can apply to anybody, but the FDCPA is pretty much just for debt collectors. And again, most of our cases bring all three of those actions at the same time, or at least two of the three, depending on who the other party is and what type of phone was used and things.
Right. Because I know there's been some cases where the courts have held that a TCPA violation does not establish an FDCPA violation. Would you like to speak to that?
True. I mean, it depends on, again, that consent. If the consent was verbal if the revocation for consent to call was verbal under the TCPA, there's an argument that violation, that phone call, would not be a violation of FDCPA because they require the cease and desist to be in writing, for example. And then also, we have another cause of action called the Fair Credit Reporting Act, FCRA. And nowadays, the judges are getting to be they're kind of rearing back on the TCPA claims. There's been a lot of very large verdicts. There's been, unfortunately, some professional plaintiffs out there that are collecting phone calls in a way that is very damaging to multiple creditors. And we're not looking for professional plaintiffs. We're looking for, a consumer in need, a family, someone that's getting these phone calls at dinner time, middle of the night, stuff like that. We're not looking at someone who is, filing 10 cases a year. That's not our typical plaintiff. And so the FCRA is something that judges, if they're rearing back from the TCPA and the amount of damages that kind of a case can bring, they're not doing that for the FCRA. And the Fair Credit Reporting Act is more damaging. I mean, the violations are more damaging than you think. I used to think, well, who really cares if they have a wrong entry on a credit report? A wrong entry can actually drop someone's credit score by 50 to 75 points, and that can cause someone to not qualify for a home loan or have a lot higher interest, not get insurance, not get a tenant-landlord relationship, all kinds of things. So we're seeing big verdicts, a lot of damage, and I think the FCRA is kind of the new area to get into now.
I think it is too, and I want to just cut in real quick, Storm, because I, as a consumer credit consultant, this is what I help people with, Christie, and it's actually, the points can actually be higher if something is wrong. For example, if a collection appears on a report, even though FICO doesn't give points, I can tell you it can actually be up to 100 points. It's bigger than you think. And if they have a late mortgage payment that, let's say, really was not late, it's up to 200 points. So it's huge.
Wow.
But I know, from being here in the Tampa area, over the years, I've talked to different FCRA attorneys, and there aren't that many. Most of them don't actually seem to know what they're doing, or they want a huge amount for a retainer. And I know that not too long ago, let's see, in June of 2017, TransUnion had to pay out $60 million because they violated some of the FCR provisions. Let's just see. It says TransUnion failed to follow reasonable procedures to ensure maximum possible accuracy of the information, clearly and accurately disclose all the information in the plaintiff's consumer reports upon their request, and they failed to provide plaintiffs with a summary of their rights under the FCRA. What's interesting to me about that is they never disclose all the information in the plaintiff's consumer reports, the way it's done through a Metro 2 form. So when I look at a credit report for a client, it does not necessarily show all of the information required when it's coming from an original creditor. What's worse is that when it charges off and goes to, say, a collection agency, then that collection agency puts the date they bought it as the date of initial delinquency, and they re-age the debt. But no one stops any of this practice at all, and consumers have no clue how it works, which makes it even worse.
Yeah, they don't know how it works, and they don't even know it's happening because most people don't regularly look at their credit reports. And I've been reading more on the FCRA lately because I'm looking for it to maybe fill a hole if the TCPA does eventually go away here, which I don't know if it will, but it could. And so FCRA, we have a lot of, maybe 9 out of 10 reports might have some kind of violation on it. And Experian got hit with a $3 million judgment just a couple of months ago also for not having reasonable procedures in place too. We are getting ready to bring a class action against a creditor that is not re-aging the account, but what they're doing is after a dispute was validated and the debt was taken off of the credit report, the debt's been assigned to a new debt collector, and now the new debt collector put it back on a credit report with no notice to the consumer, and that's a violation. So the key with the FCRA is that you've got to pull your credit report. And so annualcreditreport.com will let everyone get a free annual report, and you have to dispute the error before a claim exists under the FCRA. And so the key there is you want to remain overly broad. The disputes can be made online fairly easily, but you want to remain overly broad when disputing. And it's best to state simply that the account is inaccurate, incomplete, or unverifiable. And so just leave it broad like that: inaccurate, incomplete, or unverifiable. And then what happens is that triggers a mechanism where the credit reporting agency has to verify the debt through the reporting creditor. And if the creditor verifies that debt, then you would have a claim against both the agency and the creditor for this inaccurate information. If the debt is corrected, then of course you would not have a claim. And so when you've got a paid negative account, dispute it. Most likely a debt buyer is probably not going to be too interested in spending the time and money to verify the debt. They've already been paid. And one last key is it's good not to dispute more than 3 at one time, because you do have to show a good faith basis for having made the dispute. So therefore, we don't suggest you dispute everything on your credit report, and you do want to be fairly broad in your dispute, because you're not necessarily going to know what's wrong. You just know that it's not yours, or that's not right, or something. But I think that that's going to be a growing area, and so we're looking more and more into doing that. And this one class action I'm particularly excited about. I think they needed to give notice that they put that back on someone's credit. That's after they disputed it and had it removed, and they had no notice that was even done.
Yeah, but
they would never know.
In the years I've been doing this, I've never seen that happen. They really don't care. They think no one, they're getting away with it for this long, and that the consumers are dumb, basically, because they don't know what the laws are, and they just go ahead and continue to do the same old, and that's why. Therefore, I find it frustrating for my clients, or for consumers in general, because when you dispute with the credit bureaus, all they're really doing, they optically scan the disputes and they convert it into a 2-digit code. There's approximately 22 codes, I believe. And then they use a system called eOscar, which basically just that program scans out that 2-digit code to all those creditors and collectors. So most of the time, they're not even looking in the computer. Whatever's in their computer just scans back through this program, or emails back through this program. So it's disturbing when, for example, if you have proof of something that's incorrectly reporting and you send it to the credit bureau, certified return receipt mail with 2 pieces of ID, and they send it back and they won't change it even though you have proof. And the reason why is because the collectors and the creditors are actually the paying subscribers. The consumers have to realize that they are not the customer to the credit bureaus. That's
a great point, and that's exactly what I tell my clients with their student loan servicers. The servicers are not treating the borrowers as their customers. The customer is actually the creditor. And so when you're talking with your loan servicer, you're talking with a debt collector for the other side. They're not required to advise you as to what your best option is, what to do, how to do it. They represent the other side. And it's the same thing with these credit reporting agencies. Their customers are the creditors. And so, the borrower and the consumer rights is not really where their interest lies.
Okay. Well,
I think it's fairly obvious that these different statutes all kind of rub up against one another and become convoluted. That's why it's necessary and imperative for a borrower to contact somebody such as yourself who's fluent in the law, because if they decide to do this themselves, they can go to court where they sue on an FDCPA violation, which they really didn't have. It was really a TCPA violation. But now they're collaterally stopped from ever bringing a TCPA violation because they used it up in their action on the FDCPA. So,
you're right.
So it's really important for our listeners to understand that they need to get competent legal advice before they do anything, because it's such a convoluted area that they don't understand it. Might just be getting themselves in trouble.
Yeah, and with a TCPA claim, there's a lot of background work that has to be done that a consumer wouldn't know how to do, to evaluate the phone system as a whole and subpoena the phone records. There's certain ways of doing things that a consumer wouldn't know, and if they think they would go to court and just tell their story, they would lose because they wouldn't have enough evidence to meet the burden. Right.
Yeah. Well, I got another question for you on that, but we're going to do a commercial break, and we come back. We've got about 10, 15 minutes left, so we have some more questions for you, Christie. Stay with us.
Okay. Yep, sounds good.
Okay.
Consumers, do you have bad credit? Can't purchase a house or car? Paying too much in interest on your credit cards and loans? Scammed by credit repair companies? There is hope. you can get back on track and do it the right way. Call Credit Education Consultants today at 813-500-6064. That's 813-500-6064. Or go to crediteducationconsultants.com now and get the help you need. Don't delay. Call today. Mortgage reps and realtor inquiries are also welcomed.
We're back with our special guest, Christie Arkovich, and I guess you would be called a consumer rights attorney, wouldn't you be, Christie?
Yes, I refer myself as a consumer attorney. Yes.
Right.
And I got a question. I'm going to button here again, Storm. So, when if a listener's listening to the show, we want them to hear it. So, as an example, when I get a client who says to me, I ask them, are you getting any type of collection calls, any type of robocalls? And their typical answer is either I don't answer them or I just call block everything. Now, tell me if this is right or wrong, because I usually tell them, unblock it, take the call, give them the opportunity to, under the FDCPA or FCCPA, to be harassing to you. Because all they have to say is, send me validation of the debt, here's my name and my address, I'm not giving you any more information than that, and, let them call instead of saying, if they're going to continue to harass that client, maybe it's actually better for them to do that, to build up a case.
Yeah, we often will take that same approach. You'll see a little bit of pushback from the plaintiffs, from the creditors. They'll try to argue that the consumer didn't mitigate their damages. They didn't send any request in writing not to call, even though they were instructed to by the creditor and things like that. And they try to argue to the judge that this consumer is sitting back and just collecting phone calls for a payday someday. But how we try to argue that case is that call blockers don't really work all that well because of call spoofing. I mean, they may call from 10 or 20 different phone numbers. And if you have 2-3 creditors, you're talking like 40 different blocks, and they keep changing all the time. So I'm not sure call blocking is really all that effective. I would do exactly what you had said, Laura, is I would go ahead and, or Lori, I'm sorry, I would, basically tell them not to call and just keep a really good track of that and use it aggressively. If they choose to continue to call, then those violations may cause you to, at the end of the day, not owe that creditor any further money if it's a creditor, and if it's a marketer or something else, have a damages award against a company for collection then.
Right. I wanted to share. Go ahead, Storm.
Go ahead. I just had a quick one, and she can answer this very quickly. So, Christie, if I just have one violation, is it still worth it for me as a consumer to call you?
Probably not. We do not pursue cases where we're just talking one phone call or something like that. But that being said, here's an example from earlier today. I had another attorney that contacted me. He said, okay, I have an armed services credit card, and they're saying that it's a student loan debt. So he was asking what he can do about that. And so I said, well, if you are basically a creditor and you're basically inferring a right that does not exist or asserting a claim that doesn't exist, then you're in violation of the Florida and federal debt collection laws. And so what are they doing by telling someone it's a student loan? Well, a least sophisticated consumer would basically say, well, it's a student loan, I can't discharge this, so there's no point in filing a bankruptcy. No, it's not. It's a credit card debt. You can discharge that in bankruptcy. So they're asserting a right that doesn't exist. With the least sophisticated consumer standard, they probably would lose that case. So that's only one phone call. One person told them it's a student loan, but that case is potentially worthwhile because a lot of people, they want to pay their armed services credit cards, but it's accruing interest and maybe they're in garnishment at 25% of their pay. So perhaps we can use that violation to get rid of the garnishment, agree to a payment plan that's a lot lower of a payment, and totally get rid of interest going forward so that every dollar is paid going to principal. That potentially could save that person thousands or tens of thousands of dollars, and they had one phone call. So it's not always the case, but if someone came to me with one cell phone call, I probably wouldn't be interested in that case. But there are exceptions, like I just mentioned.
Yeah, and I wanted to kind of share what happened with me because I had a family member who used to live with, and somehow the student loan company called my phone. They skip traced me and actually called my business line, and I just kind of played dumb because I knew right away, just from the way they spoke to me on the phone, they were asking for this person, and could I get a message to him? And right away, red flag, I know it's a debt collector. And I said, I'm not contacting this person. I said, you're calling me, a total stranger, and I need to know who you are if you want me to pass that message along. And so basically the woman gave up the information. And so I contacted my friend, and anyway, long story short, he won $1,000. So that's a small case, of course, but he did win it. Maybe if they had called multiple more times, they would have totally gotten the debt discharged. But, you have to be careful as a family member of someone who's in debt, because some of these companies, they'll call your employer, they'll call your family members or your friends or your roommates or people they can track down. But it's embarrassing for that person who's in that situation to find this out, like they're getting a call from their parents going, oh, you're in debt, we just got a call from a debt collector.
Right. And even though you might only be talking about maybe one call, $1,000, in some instances that could still be worthwhile. Like for example, we had a case a little while ago where we had a single mom with 3 kids, and she could never save the money to file bankruptcy. But she owed a ton of debt, mostly all credit card debt, and because her husband had left her and she didn't have a job for a period of time. But she had one creditor that was calling her work, and her employer actually got on the phone, her manager. And unfortunately, the creditor called him a pretty nasty name that I won't repeat on the air, but that manager wrote a statement for us and said, hey, I got on the phone with this dude, he called me whatever, and so we filed a lawsuit. And we ended up settling that case, and the client paid for their bankruptcy from that case and pocketed a little extra money because I think she needed to move apartments and fix her car. So both of those things were paid for free by the creditor who had violated the law. My attorney's fees were paid both for the violation and for the bankruptcy. So when she told me she couldn't pay for her bankruptcy, but she told me that her work was getting phone calls, that's what we did for her. And so even though it was not that much, it was a lot to her. And she had spent mostly the better part of a year trying to collect up the deposit to file bankruptcy. And she couldn't do that. So it was a really good result for someone like that in that position.
Right. So if you're listening, there's a possibility if you're getting these calls that you might actually win money.
And Laurie, you mentioned that sometimes they'll re-age the account on the FCRA. And that's true.
Right.
You cannot re-age the account. It basically can stay on the report for up to 7 years from the date of first delinquency. And so if you see upon an assignment to a different creditor, it's a new date, so it's going to last 7 years from that date, that would be an illegal violation as well.
Exactly right. But most companies, I hate to say, most companies do that. And even if the client sends out a validation letter asking for the date of initial delinquency, I'm going to tell you only about 50% of the time do they respond. So the other 50% of the time they're not going to tell you because they did something wrong.
Yeah, that could be. And so when you dispute these credit entries, either you're going to have it removed, which is better for your credit, and that's a free process, or they're going to leave it on there, and there's a good chance it's probably a violation, in which now you can sue.
Right. Storm?
No, I'm just kind of sitting back like listeners and enjoying this.
Yeah. Well, I'll share with Christy because we're going to try and get somebody on from the U.S. Treasury, hopefully. But I'm going to tell you, about a month ago, over a 1-week period, I received 30 phone calls from a call center, because you can hear everybody talking, a foreign call center, or at least a foreign speaker, who kept calling me up saying, Laurie, look, you have won a $9,000 windfall from the U.S. Treasury, and you don't have to pay it back. And I could play with them a little bit. I go, you just made a TCPA violation. I'm recording this call. Click. Whatever I would say, she's recording the call. But in a 3-day period, I got 30 phone calls. The problem is, like you said before, maybe someone will change the law so that the number they're actually calling from is the number to track down. Because when I reverse Google a lot of these numbers, and in one case I even called back a number that appeared to be local, and I didn't get the whoever was doing it. I got some legitimate person whose number they used, who must have been confused why people were calling him back.
Yeah. Well, some of those laws have gone into effect. I think in November 2017, the FCC did adopt some rules that let phone companies like Verizon and such block calls from area codes that don't exist, or numbers that aren't assigned to anyone, or entries on a do not originate list. And so I understand that that's been very effective at stopping those IRS scam calls, because for the last year or so, a lot of IRS scam calls were going out to attorneys and other folks saying you owe the IRS, and people were very scared and starting to pay. And what they've been doing is they were spoofing an IRS hotline, but now it's on the do not originate list, so those calls, I understand, have mostly stopped. So they're trying to take advantage of technology, even though the FCC, being a bureaucratic agency, isn't really on the forefront of many things, but they're trying to take advantage of some technology, work with other companies in the field to address these call spoofs and make it so that the caller ID means something again, because right now it doesn't mean a lot.
Right.
Christie,
and I think people have to be cautious when they answer calls that they don't know, it's not programmed in their phone, because something, my mother just got scammed not too long ago, and I said, you cannot pick any calls unless it's already programmed in your phone, because with the elderly, that's where people take advantage and they get scammed out of their money.
Yeah, and my understanding is the common instruction for that is if you're getting robocalls from something that you've never had anything to do with, it's not a debt collector, no one that you've ever had a prior business relationship with, the key is there to hang up as quick as you can. Don't engage. If you talk to them, if you press a number, say anything back, if you call them back, basically that scammer, which is probably who it is that's calling you, they can then sell the number. And now that number it usually is worth something because they know there's somebody on the other side of it, and the call volume can actually increase. And for someone elderly, they can get talked into all kinds of stuff. We will hear from clients who say, I need to, send this person $2,000 to get my niece out of jail in, Timbuktu. And they just believe it. So, yeah. The thing is trying to figure out who's making the call. So debt collection laws, the FTCPA and FCCPA, they require a debt collector or creditor to identify themselves. And so it's a violation when they don't identify themselves. So if you have a caller that refuses to say who they are, that's a violation of the law, but it's probably a scammer because most legitimate companies will actually say, well, we're from, whatever creditor's name it is.
Right.
Yeah.
Legitimate ones, though. The phone is
legitimate ones.
Get an important question in here for our consumers. You and I refer to it as the statute of limitations. Most consumers see it as, hey, how long do I have before I can sue? Why don't you tell us what the statute of limitations are for these different acts?
Sure. Great question. The FTCPA is rather short. It's only 1 year. So you basically have 1 year in time to bring a lawsuit, to start a lawsuit from the date that the call or whatever it is that was made. You don't have to finish the lawsuit, but you have to at least start it. Our FCCPA is 2 years, and the TCPA for cellular phone calls is 4 years, similar to the FCRA for credit reporting. That's also 4 years. So you can't wait too long. And the problem with waiting, 4 years, even on a 4-year statute, is that you'll forget. Your memory won't be as strong. You might lose documents. Your phone records may not have been kept. Your bank records may not be kept by the entity, the bank, the phone company. So you really don't want to wait that long because your case is probably going to weaken as time goes by. So we don't encourage that, but that is the statute of limitations, and that's basically the time period that someone has to sue on a violation.
All right, Christie, before we let you go, tell us one more time, spell out your name and how we can contact you.
Okay. It's Christie Arkovich, so it's Christie, and last name is ARKOV as in Victor, ICH. So our website is ChristieArkovich.com. My email is Christie@ChristieArkovich.com. Notice a pattern here. And our phone number is 813-258-2808. And we have a website that has a lot of information about each of these laws, as well as a couple free ebooks. One in particular is How to Take Your Life Back from Your Student Loans. That's particularly popular among our clients because, everybody with student loans, they don't know that there's anyone out there to help them. So people now have heard of these debt collection laws, and they usually will realize that, hey, I have a violation, I should reach out to someone. With student loans, they don't know there is someone. And so we're really trying to have people share that with others and let them know because, it's very common to have 8 out of 10 people with student loans out there, and they're suffering when they don't have to. And so we can usually get their payment down to something that's affordable and sustainable with an end in sight instead of the rest of their lives, which is what it is now. So that is in particular something we're trying to get the word out. And going forward, I think the TCPA is going to weaken a little bit, but I think the FCRA is strengthening and, perhaps taking its place a little bit more with some of the actions that I see out there being brought by consumers.
Great. Well, we want to thank you. We're out of time. We want to thank you very much. And Storm, thanks as always for asking those great questions.
Well, thank you for the opportunity.
Oh, you're very welcome. And thank you all for joining us today on Fraudsters Radio. Please join us again next Monday from 1 to 2 p.m. Eastern Time live. And remember, we want to hear your stories. You can contact us through the Fraudsters Radio Facebook page.
We're out of here.
We're out. Thanks, everybody.
Okay.
Bye.
Thank you all. All right.
Bye-bye.
Have a good day. Bye-bye.